Hello class and welcome to your week 13 lecture where we will be discussing the interplay between research and reentry policy. As a reminder, our learning objectives for this lesson are that by the end you should be able to analyze the interplay between research and policy in reentry, summarize how individual level characteristics, community and social conditions, and public policies intersect to negatively impact successful reentry for those with a felony conviction, support the use of education as a tool for reentry, and discuss mitigation-focused reentry as a mercy-oriented approach. The first article we're going to discuss is Education's Failed Promise: How Public Policies Educate a Criminal Underclass. And what she discussed in this is that there are various impacts on reentry when we look at individual level characteristics, different conditions within the community and social conditions, as well as public policies that can all lead to an unsuccessful reentry for a person. When we look at the individual level characteristics, we're talking about things like a lack of social capital, unreliable or various types of family supports, having a mental illness or a substance abuse disorder, even the type of criminal conviction that one has. We'll see in a minute here how drug convictions really negatively impacted reentry for individuals because of different policies that were put in place. And also the conditions of post-release supervision. So what are their conditions? What do they have to abide by? What is their parole officer asking them to do or requiring them to do per their court order? We then look at community and social conditions. So these are as a result typically of overburdened nonprofits. These can be communities that are experiencing institutional abandonment, which leads to low-performing public schools and even having high rates of poverty within that community. Only 30 to 35% of individuals in this study earned a GED while they were incarcerated. And they noted that a lack of education and resources were the reasons for why they did not decide to pursue an education when they were re-entering society. And then we look at public policies where there are ones even outside of the criminal justice system that we can call secret sentences or those invisible punishments that really impacted reentry for individuals and the opportunities that they had made available to them. So there are very important connections between education, employment, and reentry, as we've seen throughout this entire semester. So when we talk about public policies, let's actually look at a few of those that could impact this. So the first thing we need to note is that punishment and control was being elevated over rehabilitation through public policies. So the 1982 Senate report supported this notion that nothing works, and the federal system had said that they failed at rehabilitating offenders. The 1984 Sentencing Reform Act then decided that they needed to adequately punish offenders through longer sentences. So they had a goal of reducing sentencing disparities in criminal sentencing, but also ensuring that criminals were adequately punished. When we look at the Anti-Drug Abuse Act of 1986, this was those policies that came out that were your war on drugs, your zero tolerance policies where youth who even had a cigarette in school or who had a knife because they forgot that they were hunting over the weekend. There were zero tolerance policies. Everyone was getting arrested and getting charged. You also have your tough on crime policies and your 3 strikes and you're out. So after 3 convictions, you were out. There was no more chances for you. When we look at the 1988 amendment of the Anti-Drug Abuse Act, we see that this denied all or some federal benefits to individuals who were convicted of a drug trafficking or possession offense. So we talked about these when we talked about collateral consequences and how individuals were no longer able or eligible to apply for certain government benefits. That's this policy. When we look at the Violent Crime Control and Law Enforcement Act of 1994, they had goals of public safety and crime prevention, but also of incarcerating violent offenders, which was leading to increased sentences or longer sentences for those who committed violent acts. Looking at the Higher Education Act of 1965, this is where Pell Grants came in. So the goal was to increase the number of low and middle class students to give them access to higher education. The amendment in 1994, however, the amendment in 1994 of the Violent Crime Control and Law Enforcement Act now did not allow any former prisoners to obtain grant funding to attend higher education schooling. So less than 1% was actually using this grant. Less than 1% of prisoners were even using it, but they still felt the need to include this in the act, so they were no longer allowed to use it. And then another amendment actually made most felons ineligible even after serving their sentence. So that's that 1998 amendment to the Higher Education Act. So those who were convicted of possession of a controlled substance were ineligible for 1 year for their first offense. Those who were convicted for a second offense were ineligible for 2 years. And then after the third drug-related conviction, they were indefinitely made ineligible to obtain Pell Grant funding to attend college. And the last act we need to discuss is the No Early Release Act of 1997, which actually mandated that prisoners serve 85% of their sentence before they could become eligible for parole. And what some prisoners noted is that what this did was it removed sort of that degree of incentive for them to participate in programs or education in prison, or to not get into fights, to have good behaviors, because the good behavior, the good time rule, while it still applied, it wasn't getting them out as early as it would have pre-1997, this act. So what did education look like in the New Jersey prisons for this study? Well, common courses that were being offered were your adult basic education and general equivalency development degrees. They also offered Alcoholics Anonymous. So while these were the most commonly made eligible education programs, they tended to have a lot of barriers that stood in the way of individuals actually participating, particularly in the first two. So lack of qualified staff and resources. They also had a lack of books. And when we talk about qualified staff, we're talking about ones that are certified and proficient to actually teach these courses. And in New Jersey, when the real education curriculum funding was eliminated, they actually then had to turn to more certificate programs, which are nearly useless in the real world. So things like your Alcoholics Anonymous, things like financial literacy courses or anger management, while it's great and they may receive a certificate for completing that program, it's not something that really is going to attract a future employer. Other things we needed to look at when we talk about barriers were security issues. So because of security threats, because of the lockdowns that would happen, because of fights that would break out, because they needed to make sure that individuals were secured and put in specific places, that this really made it a tough time logistically to have these courses being offered. So what they did instead was, when they had these more certificate programs come in, they would instead have reformed lifers facilitate the courses instead of those trying to find qualified staff. And you didn't have as many security issues then with bringing outside individuals in. And the reformed lifers did tend to find value in facilitating these courses for other prisoners. And one other issue that these individuals noted was that parole tended to push employment rather than pushing education for them, because education, unfortunately, isn't going to help them get better housing. It's not going to help them be stable in the present moment. It's not going to help them be able to feed their kids, feed themselves. So parole really tended to push them obtaining a job rather than education. So how can we use education as a reentry tool? Well, we need to make sure that we look at education as a core resource, that we also look at education as what the research tells us is that it reduces recidivism. It also improves the chances of someone finding employment and finding gainful, meaningful employment. However, the number of prisons that were offering educational programs actually dropped from 1994 through 2002. So in 1994, you had 40 states in the US that had prison education programs, And by 2002, only 22 had education programs. So this was a 55% decrease. There are also barriers to education in reentry. So when we look at what an individual needs to reenter successfully, we have to talk about what their priorities are. Is their priority to feed their children? Is their priority to make sure that they have stable housing? What are their priorities? Do they have the time to seek an education that's going to take to put into the studies? Having a lack of resources, so do they have the financial means to actually pay for the schooling if they're not eligible for, say, Pell Grants or financial aid? Having a lack of social capital, so not having well enough support systems around them that they can actually lean on for help and guidance to tell them what they need to do to enroll in school, how that works, what paperwork do they need, what classes should they take, do they have anyone to watch their children for them while they attend classes? And then again, that unfortunately being ineligible for financial aid, which really creates an issue for a lot of returning prisoners. So now we'll discuss the mercy-oriented reentry and reintegration, lessons from policy, research, and practice. When we talk about mercy-oriented reentry and reintegration, we first need to talk about policy and practice. So we had this shift toward determinate sentencing using sentencing guidelines, which increased proportionality for offenders, so everyone was getting more proportionate sentences, and it made sure that our judicial system was in check, that they weren't, applying a very large sentence to one person, but then either that same judge or a different judge applied the law very differently to someone else. What this does not do, though, is take into account individual factors into consideration. It's simply based on a prior record score and the offense gravity score of the current offense that they've committed. When we look at the case of U.S. v. Booker, the Supreme Court here actually held that sentencing guidelines violated the Sixth Amendment right to a jury trial. So instead of these sentencing guidelines being mandatory, they're now advisory. So while judges should be following these sentencing guidelines, they can actually depart from them if they put a reason down on the record. So what we now have are sort of varied sentencing policies and practices that are in place across the country. And what we really need to be doing is taking into account the social aspect of humanity when we're sentencing individuals. So the idea is that we need to help reentrants create a life in which they're more likely to choose law-abiding behaviors in the future rather than choosing criminal behaviors. When we need to also look at a communitarian vision for punishment. What this means is that we have a goal of facilitating positive freedom. So individuals have the capacity to develop themselves as members of a community, which includes their ability to act on and shape their own environment. So they need to have a say in what happens to them. So how does sentencing mitigation play into this? Sentencing mitigation takes into account the human story. It takes into account character, human frailties that we've really talked about at length in one of our weeks, talks about their upbringing, their families, who their parents were, what their childhood was like, and their capacities. Talks about their capacities to engage in education, their capacities to engage in programming, treatment, services, and their capacities moving forward as an individual, as a contributing member to society. So the National Alliance of Sentencing Advocates and Mitigation Specialists is actually a national association that sets ethical standards and provides training around the country for anyone who wants to be a mitigation specialist. Typically, this is going to fall under the Public Defender's Office. And actually, there are guidelines for death penalty cases that were set by the American Bar Association for death penalty cases. So this says that no fewer than 2 defense attorneys, an investigator, and a mitigation specialist need to be there and need to be involved in death penalty cases. So what a mitigation report does is it ameliorates a prison sentence or asks for an alternative to incarceration. It also helps build a case for context of that offense that it happened in and engages the court in mitigation-related issues. So typically issues that would maybe not come up In typical cases, a judge isn't going to sit and ask about the childhood of an individual. But because these cases are so serious, it's very important to look at these mitigating factors. And we could even have the discussion of, is it important to have discussions on these mitigating factors outside of just death penalty cases? Outside of just looking at maybe in the current present context where a public defender may, or a private attorney, whomever for the defense, would argue and say, Your Honor, we need to really take into account that while this female maybe has committed, retail theft in the past, and she's here again for another retail theft. She has 3 children. The father is incarcerated, is not present or able to contribute financially or give support in these children's lives. She's working 2 jobs, and what she stole was clothing for her children because the school year was starting, and we'd like you to take that into consideration. Sure, that happens now, but these mitigation stories are really taking on the whole human story of this person. And we'll talk about what the components are of this in a later slide. So what it does is it recognizes that life histories actually inform individuals' behavior and their actions, that people are shaped by their social histories, key events that happen in their life, as well as personal relationships and opportunities that are made available to them. So the moral purpose of appealing to mercy or empathy here is to see the person and not the crime. And it's also important that we look at early childhood, we look at their institutional lives, whether that was as a juvenile or as an adult, and their future flourishing. What is their direction and abilities of that person in their future? These are all things that are included in sentencing mitigation. So what does mercy-oriented reentry and reintegration look at? We need to look at 2 differences here between mitigation-focused reentry and reentry-focused mitigation. The first one, mitigation-focused reentry, acknowledges that it draws from comprehensive life histories. It also advocates for individualized services for that person, and it requires that the specialist has an in-depth knowledge of programs and practices that are available within that person's community that they can rely on. And it requires knowledge of what works for programming and what doesn't work for programming. What reentry-focused mitigation does is it recognizes the presence of failure, rearrest, and reincarceration. This is a reality of reentry for a lot of folks. But it still advocates for an individual's potential to live free from being in the criminal justice system or having some type of involvement with the CJ system. So it sort of envisions this package of ideal services and opportunities in the realities of that we're operating, where we have collateral consequences, where we have a poor labor market for reentrants, and where we have social welfare issues for these reentrants. So taking a brief look at Philadelphia's mitigation protocol manual will really just help to give us an idea of what is all included and what this looks like. So here are the main components of these reports. They will conduct interviews with the client as well as their families, and it won't just be one interview with the family. They'll have multiple interviews with the family, because maybe once they interview the mother, then they go back and interview the father. The father mentions something that happened in that individual's childhood that involved the mother. Maybe the mother was verbally or physically abusive towards the child. So now they need to go back and interview the mother again and get more information. This is an ongoing process. They'll look at the juvenile file and any pre-sentence reports they have from them as an adult. Even the Department of Human Services file, so their DHS, were they involved with the child welfare system at any point? They'll look at their school records, look at educationally, academically, behaviorally. They'll look at their attendance records, any records from the schools. They'll also look at different mental health, medical, and drug treatment records. Is there anything there that the judge needs to be aware of? Do they have a chronic medical condition? Have they had a mental illness? Do they have depression? Do they have a reduced cognitive capacity? All great information for the judge to have when they're sentencing. They'll also ask for prison records and military records to be able to review. And then after they review all of these above, they will determine if there are other records they need to obtain, other interviews they need to have with other individuals. Maybe they're going to interview staff from a former institution they were in, or professional evaluations that are needed. They will then collect and report on all of the trauma and deprivation that was suffered by the defendant. They will look to report on an explanation of impact that can have on normal development. So what does the trauma, what does that deprivation that they had suffered, how does that impact normal development of a person? Is there evidence of remorse for this person? Is there evidence of positive performance in jail or previous juvenile structured settings or institutions? And they will look at the good the defendant has accomplished and that they can accomplish. So this really takes on sort of that mercy-oriented approach that we talked about in a few slides ago, looking at this person from a humanistic standpoint, looking at them not as a crime, but as an individual who has had life experiences that has shaped not only them, but that has shaped their behaviors and their actions. And how has that impacted where they have now landed today in front of a judge? So could these mitigation reports have value in places other than just for death penalty cases? I would argue yes, though you would hope that you had detailed pre-sentence investigations done on every case for every offender going before the court, but unfortunately that does not happen all the time. Sometimes those interviews are actually conducted over the phone. They're not even conducted in person with that individual or defendant. And what I think is great about these mitigation reports is that it collects information on their childhood. It really looks at what has happened to this person to impact where they are today. And can we take all of those things into account? So in sum, a lack of resources, lack of educational programs in prison, and an emphasis by parole on obtaining education really leads to an undereducated reentrant population. Policies have gravely impacted educational outcomes for reentrants. We look at mitigation-focused reentry and reentry-focused mitigation. They both emphasize showing individuals dignity and giving them mercy in sentencing. And finally, mitigation is a process that must be comprehensive to provide all information that's pertinent to that individual to the judge for sentencing. So that was your week 13 lecture. I hope that everyone has a fantastic week.